Yeah, I think it's tough. When we chose them, I don't think we even realized we had made a lot of the decisions. Like how relevant players, and how many players would be. So, teaching them a great day. Yeah. If you have 10 minutes, you talk to a girl, it's full in here. Great. Yeah.
On my colleagues show.
Yeah. You can ask them all. She's just so smart.
But over time, she was my mentor and became my graduation. I was saying, my daughter's college doing, so we work at Wiley Rein. We really take care about her, and it was bad. So I was like, I'm going to go meet this young woman on her birthday, and then it turns out she was great. And we all
It's important. Oh, you have to.
So nice to finally meet you.
I know.
I feel like so much email correspondence and like.
Well, I'm always up on his face in New York, but since I do media, they bring me up on. I'm up there for a lot of different things. I'll have to stop by when we're in between some.
Yes, please do.
She's very brave to not be a native and do that.
Oh.
So I have a job at a right here in DC. So it worked out better. I feel like turning down it's a better job. And I just almost it could have worked out better. It was a very stressful few months.
But I say sometimes they work out.
Yeah. Yeah. That are just waiting it. No, it was one of the things that was like, I don't even want to think or try it. Place to go. Just in an area that's
I needed some good.
yes, there is something for all this. Also, within 3 days we I think it's a lot of yeah, one of those hardly stuck. Great, but I am ready.
Nice to meet you too. Yeah, new gardens and things ever since. Yeah, I was looking at, the independent study, but, and then, no, that was oh, yeah, dropped out, yeah. Yes. It does, no doubt. Yeah.
Hi. So nice to meet you. Thank you so much for making the time. I know you look prepared.
Yeah.
joining us. Did everyone enjoy lunch? Yeah? All right. So, before we get into our third panel, please join me in welcoming Kathleen Kirby, the president of the Federal Communications Bar Association, who will be speaking with us today.
Thank you, Sahara, and good afternoon, everyone. Love to see this full room, and I'm so pleased to join you today as you delve into privacy, surveillance, and the modern landscape, all topics at the core of TMT legal practice. I want to thank FCLJ's editor-in-chief, Addison Spencer, and of course, Sahara, the Symposium editor, the entire volume 77, FCLJ staff, and GW Law, for inviting me and our FCBA President-elect, Matt DelNero, to be a part of this 2025 symposium. You know, many years ago, I was a staffer and then executive editor of the Law Review up at Catholic U here in town, where I was part of their then nascent Communications Law Institute. We had to do a write-on regardless of grades, and I did mine on an IBM Selectric typewriter. And let me tell you, lining up the footnotes just right was really a bear, so you guys consider yourselves lucky. But the rest of my journal experience I still treasure, as I hope you have, for fine-tuning my approach to analysis, honing my writing and editing, testing my leadership and organizational skills, introducing me to thought-provoking topics and esteemed authors, and leaving me with friendships that endure to this day. Before I weigh in with some observations about the important discussions the FCLJ is facilitating today, I want to say a few words about the FCLJ's success here at GW Law and about the strong relationship between the Journal and the Federal Communications Bar Association, which many know simply as FCBA, or the Tech Bar. We are a national bar association with vibrant chapters in DC and across the United States, with strong roots in the field of telecommunications, media, and technology dating back to 1936. But as law and technology have evolved, so have we. Today, our members across the country work in an ever-widening range of practice areas, from artificial intelligence to emerging technology, media to privacy, cybersecurity to wireless technologies, broadband, and beyond. Many of the evolving areas addressed by the discussions today. As a cutting-edge bar association, we are committed to cultivating our next generation leaders and forming the strong personal connections that power our work in communications and tech. The FCLJ has been an invaluable partner to the FCBA along the way and is the official journal of the Tech Bar. Not only does the FCBA offer each of the FCLJ's 3 annual issues to its members as a benefit, but many FCBA members have written and submitted articles for consideration, have served as adjunct professors to the journal, have contributed to and attended this symposium, and have even served on the FCLJ's editorial board as law students. Our connection does not stop there, though. In fact, the FCBA's own Law Journal Committee works closely with the FCLJ's editorial board each year to strategize topical content to publish in each of the 3 issues per year. Since returning to GW in the fall of 2012, the FCLJ has continued to flourish. I'm so impressed that there is now a staff of over 60 current GW law students. The FCLJ is well represented in the FCBA's ranks as well, and it excels at bringing new members into the Tech Bar's fold. It makes sense then that as the FCBA's topical focus has shifted with new and evolving technologies, so has the FCLJ. We've both added the term tech to our official names after all. But in all seriousness, recent issues of the journal truly do reflect this technological shift. Just look at the most recent articles and notes, which focus on social media and electronic surveillance, net neutrality, First Amendment rights in the digital era, combating online medical misinformation, and more. Privacy and surveillance issues drive discussions of modern-day technology. The modern technological landscape has been filled with incredible innovations across various industries and sectors of the economy. But new innovations, as you well know, may also pose privacy and surveillance risks. These realities make today's panels and discussions particularly important. Indeed, we've already had conversations this morning about balancing these opportunities and challenges, specifically by striking the right enforcement balance in legislation. Additionally, we've heard how the FTC can develop a transatlantic approach to consumer privacy in the age of surveillance capitalism. And momentarily, we'll have what promises to be an engaging discussion about modern social media surveillance of immigrants and Fourth Amendment implications. I want to thank the FCLJ for facilitating these critical discussions that our legal profession and the broader telecom, media, and technology sector must have. Harnessing the full promise of cutting-edge technologies requires understanding and managing the risks posed by surveillance. An important part of my own practice over the past several decades has been as a newsroom lawyer, and certainly that has involved balancing privacy interests with the importance of the dissemination of truthful, newsworthy information. The discussions with lawmakers and regulators I've had about the use of telephoto lens, or so-called high-resolution satellite imagery that might depict a fuzzy image of a person in his or her backyard back then, seem quaint now. But many of the same principles in weighing competing interests apply. The law adapts so very slowly, given the speed of advancing technology, and it will be up to you to see that it develops appropriately and is applied correctly. I am honored to be part of this important dialogue, and certainly today represents a commitment by FCBA to our promise that our members will always have opportunities for continued learning. I thank the FCLJ for their very hard work in putting together another marvelous symposium, and I congratulate those of you who will soon be graduating and starting your next chapter. I also recognize that these are challenging times in the legal profession, so please know that FCBA is here to offer support. And I know our support for FCLJ will continue when FCBA's incoming president takes the reins on July 1st. Matt DelNero, who is a partner at Covington, is an exceptional lawyer with whom I've collaborated, brainstormed, and advocated on behalf of clients for many, many years now. On top of that, I've had the incredible good fortune to work with Matt in leading FCBA and improving its value to our members. He is here with us today. Ladies and gentlemen, my friend, Matt DelNero.
Thank you very much. Thank you, Kathy. I, too, am excited to be here with all of you for this symposium on privacies and surveillance, volume 77 of the FCLJ. By way of background, I've been practicing in the tech, telecom, and media fields for over 20 years, both in private practice and in the public sector. And throughout all of that time, a constant has been being a member of the FCBA. And the bar has given me so much over the years, and I'm glad to have the opportunity, I hope, to give back. It's a close-knit bar association that brings together lawyers across the public and private sectors on cutting-edge issues, but as Kathy mentioned, also just strong interpersonal connections. I first met Kathy in my very first service on an FCBA committee back in, I think it was 2010, we then called the Mass Media Committee, and since then Kathy has been a friend and a mentor, and watching her lead the FCBA over the last year has been an inspiration. I've already told her I'm going to constantly ask, what would Kathy do? And I will sometimes call her and say, what would you do in this situation? We do what we do as a bar association through a variety of activities. That's CLEs, events, fireside chats with senior government officials, seminars, and so on. And importantly, through scholarship, and that's where you all come in. We are so proud of the Federal Communications Law Journal and the work that you all do to publish the journal 3 times a year. While I'm serving as president of the FCBA starting in July, I commit to continuing that partnership with GW in publishing the FCLJ. I gained actually special appreciation for this journal when I was at the FCC during the second term of the Obama administration. That time in government gave me a real appreciation for the importance of ideas and scholarship. Whether it's a student note or a scholarly article from someone further along in their career, having access to writing and ideas that is not directed by a particular company or client, but rather the pursuit of knowledge and insight, it really does make a difference for government officials when they're really trying to figure out how to navigate complex public policy challenges. So when you're working on that note or you're site checking an article, know that even if you don't see it immediately, it does have an impact and does matter. So you all should feel really good about the work that you're doing, know that it is making a difference, and know that we're all proud of you. And as Kathy said, the FCBA is here to support you. Thank you.
Thank you both so much again for taking the time to be here. We're going to take just a couple minutes until we start our next panel, so feel free to get some water, and we should be starting shortly.
I'm glad it was a person though. Yeah. Obviously we love it. So. Yeah. So you 2L, 3L? 3L. 3L, very nice. What's next for you then? Okay, very good. Cooley is now one of the good ones, so. He's a former representative, former elected. Oh, I know. The rest of us nerds are like, we have to be up at the table. Ben's key. Yep. Long key, I guess. Considered? Yeah, all things considered.
All right, everyone, please join me in welcoming our panelists for our final panel. Let's give them a big round of applause.
Hey, good afternoon, everyone. My name is Vaishali Nandiar. As mentioned earlier this morning, this panel will focus on the issue of social media monitoring by U.S. law enforcement agencies and how it has exacerbated in recent years. So I wrote my note on this topic because I'm interested in privacy law and was particularly drawn to how emerging technologies have expanded the government's ability to monitor us in ways that were once unimaginable. I found social media to be a particularly compelling case because it may be easy to assume that social media data is inherently public in nature, not private. And that assumption is partly why it's easy for law enforcement to justify monitoring social media activity, even when that surveillance involves tracking individuals over long periods and analyzing networks of connections. But as I already might note, just because something is publicly accessible doesn't mean it should be freely available for mass government surveillance of any degree. So I'm very excited about the opportunity to discuss this issue today, especially in light of the new administration's efforts in already acting to increase social media surveillance. We're very, very fortunate to have three distinguished experts joining us today. We have Cody Bensky from the American Civil Liberties Union, Commissioner Mondaire Jones from the U.S. Commission on Civil Rights, and Tom Bryan with the Electronic Privacy Information Center. So we'll have a moderated discussion for most of the session, and then we'll open it up for audience Q&A in the last 10 minutes. So if you think you have any questions you'd like to ask the panelists. But with that, let's get started. Before we jump right in, could you guys do brief intros on yourself and kind of your work?
I'll go ahead and start.
Yeah.
So I'm Cody Bensky. I'm a senior policy counsel with the American Civil Liberties Union. I lead our legislative and regulatory work around comprehensive privacy, primarily at the federal level, although given current political circumstances, a lot of our work has moved to the states, which continue to experiment with and advance different types of privacy legislation, not only on the comprehensive front, but as well as health privacy and other venues. And then I've also been very heavily invested on our work around what I'll call civil uses of data by the federal government. Think about programs like SNAP, like Medicare and Medicaid, and that's obviously gotten me very deeply involved with DOJ. This particular issue is a very interesting one because it sort of straddles that line between what private companies are collecting and what the federal government is collecting, and it sort of emphasizes the two really can't be separated in an absolutely distinct way.
Sure. Mondaire Jones, I'm a Democratic commissioner on the U.S. Commission on Civil Rights, but I still remember what it was like to be in law school. I've had a long-standing interest in civil rights and civil liberties, was on the Journal devoted to that issue when I was in law school. After then, was in private practice at a firm called Davis Polk, which is familiar to many of you, I suspect, because they have a D.C. office, if nothing else. I clerked for a federal judge, and before running for and getting elected to Congress in 2020, I was in the Westchester County Law Department, also known as the County Attorney's Office. We are evenly divided on the U.S. Commission on Civil Rights, which I'm pleased to report to you is still funded, and no wing has been, at least for the time being, illegally removed under our federal statutes. And as someone who has been aware of the rare bipartisan interest in issues relating to big tech, so to speak, and privacy issues, was able to, as the lead on a report called the Civil Rights Implications of the Federal Use of Facial Recognition Technology, which we published in September of last year as a commission, was able to get bipartisan support for it. So I'm really proud of that, and looking forward to having that conversation today.
Hey everyone, my name is Tom McBride. I'm a counsel at EPIC, Electronic Privacy Information Center. Been there for about 3 years now. I was in law school before that, so I very much feel like I sense some fancy 3L energy here. At EPIC, I work on kind of a broad range of issues. EPIC works on all sorts of stuff. Lately, it's been a lot of Fourth Amendment surveillance issues and a lot of personal issues, and I think we will definitely be talking about both of those today. This is one of those areas where it's kind of hard to separate the speech and surveillance aspects of what's going on. So excited to talk to you.
Great, thanks. So we'll get right into it. I want to start off by framing the issue and kind of level setting for everyone. So when we talk about social media surveillance and the data that's at issue, can you talk a little bit about the kinds of information that a user's social media data can encompass? Is it just the content that they post online? What is it really referring to?
I'll kick off with a little bit, and I think Vaishali's note does a really great job of underscoring that we don't want to think of social media just as the public post that you put out there. That's definitely a big part of it. And I think we're seeing examples of ways that particular information might be important and useful, so to speak, for governmental surveillance, but social media collects a lot of information on us, and it can include private messages, which might or may not be end-to-end encrypted depending on your settings and the platform that you're using. Many of your posts will be geolocated and have that precise geolocation involved with it, which may have implications if, for example, sending photos or posts from a protest where there is active governmental surveillance. But many social media platforms are also primarily advertising companies, and so they are going to have shadow profiles on all of us that collect our web searches and our web activity that they package up together to ultimately fund their enterprise. And so behind that public-facing profile, there's a lot of information that social media companies have on all of us that's more than just the latest tweet that you said.
My primary concern in recent years in connection with the report that we just published has been the use of photographic documentation. Facial recognition technology being the topic that we wrote about and investigated. And it turns out that there's a lot of bias implicit in these vast data sets that are scanned fairly quickly. I mean, facial recognition technology being a very powerful tool with a number of compelling use cases, but because it typically consists of data sets that are mostly of white people, are disproportionately inaccurate when it comes to people of color, when it comes to women, when it comes to disabled individuals, and when it comes to older individuals, based on camera quality, lighting, the relative scarcity of images in the data set, in the data sets themselves. So those can result in false positive and in false negative matches. False positive match obviously being a result that says that these two photographs are of the same person. A false negative being a failed effort to identify someone who actually is the same person.
Yeah. It's worth underscoring that the social media plays right into that facial recognition technology, because Clearview AI, who is probably culprit number one for a lot of this, built their database by scraping the web, potentially illegally in some cases, and then extracting biometrics from what you've posted on Instagram.
We had the CEO of Clearview AI testify at our briefing here in DC now about a year ago, almost to the day, and it was between that testimony and the written testimony and the other research that we did, it was pretty disconcerting, the high rates of inaccuracy at times within the company, and it is probably the most used software when it comes to private companies and facial recognition networks.
Yeah, I think the only thing I'll add is I feel like a useful lens to think about social media data through is we probably all have the experience, or hear people talking about the experience of feeling like their phone is listening to them, how accurate it can be once in a while, extremely inaccurate, there. That's mostly social media data. So when we're speaking about government surveillance, that's oftentimes people use backing off of this social media data. Think of not worrying about an advertiser seemingly being inside your head, but one that is a government agency. That's what scares us a little.
It's helpful. I feel like another way of getting at what social media data is kind of looking at the common ways it's collected. So that's kind of my next question. What methods do the government typically engage in order to obtain social media data? What are the methods of collection that we typically see?
So I'll speak about the federal government. The report we published is groundbreaking in the sense that it is the first study of the federal government's use of facial recognition technology, if you can believe that, for a technology that is still not well understood, one that still has a whole host of civil rights and civil liberties implications, certainly a technology that is far from perfect. As useful as it is, as very useful as it is, I mean, we're talking about a technology that oftentimes has identified culprits, I mean, sex traffickers, other criminals, you name it. So on a personal note, I don't think that we should just do away with the technology altogether, but it obviously needs to be regulated so as to protect civil rights and civil liberties. So within the federal government, there are two ways that we should think about the use of facial recognition technology. One very significant way is through the grant-making process. So local law enforcement agencies receiving federal dollars that are then deployed in the facial recognition context. There is precious little oversight when it comes to that. And throughout the federal government, there is no uniform standard. Only in the past couple of years have some agencies even attempted to implement standards in terms of the way that facial recognition technology is deployed. And then the other way you should think about it is in terms of the federal government's direct use of facial recognition technology. So, and not all agencies use it. In our report, we studied HUD, DHS, and the Department of Justice. Those are the three departments that we looked at in particular. We are a commission with limited resources. And so it turns out within DOJ, for example, the FBI and the U.S. Marshal Service uses facial recognition technology directly. Perhaps more relevant for purposes of the topic of this panel, in the immigration context, an entity called HSI, Homeland Security Investigations, which is an arm of ICE, directly deploys facial recognition technology. There is, separate from that, facial recognition technology that is used by CBP, Customs and Border Protection, and TSA, the Transportation Security Administration, which almost all of you, if not all of you, have had direct experience with. But for purposes of the scraping of public social media accounts, it's HSI that does that. It's part of its of ICE's law enforcement functions.
You know, and I think it's probably worth breaking down as you think about governmental access to social media in terms of individual and then sort of mass aggregate surveillance. On the individual front, if you have publicly facing profiles or tweets or things like that, those are things that if there's an individual investigation, law enforcement may peruse those. They probably aren't doing so without a warrant. They probably were not required because of the reasonable expectation of privacy tests. But then there's a whole slew of even in individual investigations, things that aren't public facing, in which case they will have to proceed through the processes in a statute known as the Stored Communications Act that would require a warrant asterisk for the content of our communications and a subpoena or a court order for other types of information. But then of course we're also seeing mass surveillance too, where the web is being scraped in mass, and we can get into some of the details. But in that front, we've seen HSI and other federal agencies rely on private third parties to access that information. And they've roughly categorized it in three buckets. One is the surface web or publicly available information. The other is the deep web, which theoretically is behind logins, which you might have, for example, HSI with undercover accounts where they're pretending to be Tom Jones, but it's actually your friendly neighborhood HSI agent. And they will use that for then scraping and surveilling. And then the last is the dark web, which requires like an onion browser or something like that. So they are really functioning, these private vendors that work with HSI and other agencies on all three levels of the web to conduct that mass sort of surveillance.
Yeah, and just a few things to add. One is a concerning thing is we don't know. EPIC has current FOIA lawsuits against the government about this issue specifically that started back in like 2018. I know the ACLU does as well, but there's a lot we just don't know. And I'll say there are also, I think, especially the past 2 weeks, we become more aware of the importance of other types of social media surveillance as well. When you cross the border, most jurisdictions, an agent can just grab your phone and thumb through it. In most jurisdictions, they can seize it for days, weeks, or months, hook it up to a device. Some places they need a warrant before they're for that, others they don't. It's a bit of a patchwork. We've seen some agencies put out requests to schools under like Title IX orders, requesting social media data they were given about students in certain disciplinary proceedings. We have seen kind of private surveillance organizations, for example, Canary Mission, take photos of people's social media and send it into agencies. So I think a tough thing with social media surveillance is it's sometimes hard to know all the different venues by which it can happen or all of them.
So given all that, I think it's pretty safe to say that, you know, government's monitoring of social media platforms has really evolved and grown more sophisticated over the last few years. And I wanted to talk specifically about the role AI has played in that. I know AI has kind of become a cliche and like, oh, AI monitoring, what does that really mean? So that's kind of what I want to dig in with you guys on. So what does that really mean, and how effective is AI-enabled social media surveillance?
I'll answer one part of that question, which is about effectiveness. There have been so many government reports that have come out, pretty much universally saying that it is not effective. It is very effective for certain things, like making people feel surveilled, but it is not especially effective in actually identifying and preventing large-scale harms. And the reason for that is I think a lot of us recognize that AI is very useful for some things, but one thing it's really bad at is context, nuance, understanding what the human brain is slaying, you know, these kinds of things. It really is a hard time with, and that's how we communicate, especially on social media. And so not only is it ineffective at actually knowing what's going on, it ties up a lot of law enforcement resources because there's just voluminous records, and it can really result in like harmful false positives, especially for communities of color, especially for Muslim people. They've found a lot of instances of AI flagging very, very like innocuous or even news reporting activities as terrorist speech or something along those lines. So, but that's not to say it isn't happening a lot. Maybe
So facial recognition technology is a branch of. Am I doing this right?
I think it might die, unfortunately.
That's fine. So facial recognition technology is a branch of AI, and it should never be used on its own. There has to be a human in the loop, someone to be able to independently assess the accuracy of whatever results you get from relying on an algorithm, for example. It remains, I think, a very powerful tool that can be effective at solving crimes, granting and denying access to certain resources, but it should never, because of the inaccuracies that Tom mentioned and that our report talks about, be relied upon without some sort of independent cooperation. And that is one of the various findings and recommendations that we include in our bipartisan report.
Yeah, on the AI front, I mean, part of the problem here is that the term AI is very squishy. And I think in this age, a lot of times we're thinking about large language models and chatbots and things like that. Obviously, it's a much broader series of technology than that. The other issue we encounter is it is kind of a largely abused marketing term. Lots of companies will say they have AI or don't have AI, depending on what they need. But that said, you know, it's been pretty wild to watch over the past 10 years or so. This technology really evolved in sophistication. Back in 2016, the ACLU of Northern California issued 63 records requests to California law enforcement agencies. And 40 responded, and 20 of them said, yes, we are using some version of social media monitoring. All was contracted with a third-party private vendor. And back then, a lot of it was based on API access, attaching to a fire hose from Facebook, from Twitter, and basically just showing, here are the top posts from this geolocation. Here are the top posts on this particular hashtag. Wasn't particularly sophisticated, but people love to use it, and they use it, I think we're going to talk about in a little bit, for things like tracking Black Lives Matter protests and things like that. But with the sort of like blossoming industry of large language models, we're seeing more and more interest around things like sentiment analysis to understand how do people feel about a particular issue, trying to track slang and things like that. You know, the DEA has a guide to how to figure out if your kid is selling drugs online. It's all emojis, so watch out for that rocket emoji, folks. But that all raises the question of like, is AI or large language models capable of navigating that sort of, you know, human finesse around language? And I think the answer right now is largely not, because they tend to miss context, they tend to miss sarcasm and things like that. So it raises, and also while tending to be trained on, standard English, and it's going to leave out things like African American vernacular English. It's going to leave out non-English languages, and so there's all sorts of pitfalls that we potentially see with AI here. And that comes back to the question: is it effective? Well, if you want accuracy, maybe not.
And the consequences of not having some kind of human intervention along the process of relying on AI are and can be very devastating. I mean, people who have been falsely accused of crimes, where, for example, the Detroit Police Department relied on facial recognition technology, did not do its own independent human assessment of the information available, and critically, did not provide information to defense counsel about how they came to the part of the story where they, were making these accusations against the defendants. That example, a lot of this has been written about by the Washington Post, which is a great reporting on the challenges with facial recognition technologies. It is the case that there is currently no recognized requirement to disclose to defense counsel that facial recognition technology was one of the bases for an arrest and a subsequent charge. And it's one of the recommendations that we make in our report, that do be a requirement.
Yeah, I think that human in the loop, there's a lot of academic ink spilled on how effective that is, but I think one of the important things is a big plug for Office of the Inspectors General, for ECLA, for the U.S. Commission on Civil Rights, that some of that oversight is being conducted by people who don't have an active incentive to prosecute crimes, to find people who are undocumented, to ensure that civil rights and civil liberties are being respected.
And to go further, any federal agency or department that is using facial recognition technology should disclose on its webpage, for example, its facial recognition technology policy, so that the public can come to its own conclusion, and even know that such technology is being used.
I think something that all your comments have to me is that the pitfalls of AI-enabled social media surveillance, they tend to impact certain vulnerable groups bear the brunt of that surveillance. And so two of the groups that we want to focus on our panel today are immigrants and workers. So I'm going to start off with immigration-specific questions. So the first question is, how does social media surveillance affect individuals navigating the immigration system, and how may that surveillance extend and impact American citizens as well?
Sort of a question that the answer is involved in right now as we're watching. Many of the apprehensions, arrests, detentions that we've seen of records of university students and graduate students have been premised on exercising First Amendment type activities, sometimes protests, sometimes on social media. And so we are seeing that there's potentially this individual level targeting, and remains to be seen how ICE and other components of DHS are going about that. Are they using AI? Are they simply following leads? But it does seem to be that social media is a part of the practice there. And then just very recently, USCIS, which is the U.S. Customs and Immigration Service, issued a Paperwork Reduction Act notice, very wonky, should be nothing big, right, where they're going to start asking people who enter the country for their social media handles for non-citizens through a variety of forms. And that's clearly going to be implemented as part of this rigorous vetting that the Trump administration called for in the executive order they issued on day one. So they are thinking about social media actively as a component of their immigration enforcement.
Yeah, but this is a lawless administration, and so it's almost, I guess for purposes of the hypothetical, there are rules that are supposed to be complied with, and then there are those that I think the courts have not yet recognized, because the courts themselves are still trying to figure out technology guy, as you well know, part of this journal. What I can tell you is that in the context of immigration, at every international airport, when someone is entering the country, their photograph is captured. And that's true at like 53 different airports when people are leaving this country. If you are a U.S. citizen, your photo is held onto for approximately 12 hours before it's leaving. If you are a non-U.S. citizen, your photo can be held onto up to 75 years. That's the existing practice.
I'll focus on the part of the question for what does it mean for all of us, and I think I'll answer it in two ways. The first is that, maybe this is more my Tom hat than I have here, but maybe for both of you answers, but not that I think I would disagree, but one is that immigrants are just so fundamental to our country, and we've seen a lot of implications happen these past few weeks, but even before that, on the basis both of social media surveillance, and it's really focused on immigrants who are active in trying to make this country a better place. They specifically, in discovered emails, ICE targeted people who were at demonstrations, whether they were immigration-related demonstrations, abortion-related demonstrations, kind of pick your Black Lives Matter, pick your cause, and those were the people targeted first. And so I think it's very bad for all of us that members of our community who care about making it better are the ones being targeted. And I think the kind of second way I'd answer the question is, I think the focus on immigrants comes as an answer to what's wrong in the country. And they're focusing on immigrants right now as scapegoats, or as their answer to one of those questions, which raises the question, what happens next? If they successfully deport immigrants, a lot of politically active ones, and everything doesn't get better, what's the answer? I do not think the people who have the xenophobic mindset are going to be like, maybe we were wrong, and actually we need a lot more economic racial justice to fix our problems. I'm really worried about what that's going to be.
So I feel like naturally the conversation there is so much overlap between the privacy and speech issues here. So I guess we'll transition into the protest element of the conversation. So could you speak to how, the surveillance has historically been used to monitor protests? There was a mention of Black Lives Matter protests in 2020, and just talk about the implications for First Amendment rights and the broader implications for political activism.
I'll say like one or two quick things. One is just, similar to what Matt DelNero just said, it's just so clear to me, it's very clear that people are being surveilled and punished for speaking. And the administration even says this. Right now they're focusing on immigrants, so they're trying to draw this distinction by saying, we're not punishing them for their free speech, we're allowed to exclude people from our country that don't share our values. I think when you think for more than a few seconds, you see I don't think there's much of a distinction between those two things. But yeah, it's kind of funny to talk about these things when it just seems so blatant and obvious. So I can say the thing, you said it. But I think the second thing I was going to say is just, well, how has it been happening? It's a weird mixture of private and public. There's data miners company, I think we already mentioned. Companies that do kind of wide-scale surveillance of social media, of public posts only, but there's so much you can find out through public posts, and they will send out automatic alerts to police departments or executive agencies that they've contracted with, or even ones they haven't contracted with, because they're trying to run a business. And that has been a big way that police have found out about where protests are going to be, dating back, 10 years. This is not just new here. The other thing is, again, we know that agencies are doing some of this themselves, but it's hard. At least I am not super familiar with specific ways that it's
Yeah, they've explicitly used it as a marketing technique, and I think Tom alluded to this, where those FOIA requests that ACLU Northern California did 9 years ago, they found lots of emails where the company, whether it was Geophilia or Media Sonar or Data Miner, would send as part of the marketing of, here's what we have from the Freddie Gray protests, and look at all this data, where they would say, I suggest that you know, during your trial, query the protests in St. Louis, or something to that, or Ferguson, excuse me, and something to that effect. And so they were really marketing up. We are able to track protests, which is like the core First Amendment protected activity. But you also think about the fact that as we think about social media, and that was all because social media, by default back then, was defaulting to geotagging your location, posting things like that, which is still happening, even though some social media platforms have gotten a little better about their privacy by design. But when you think about social media monitoring, especially when it's being done in such an explicit way that we're going to demand your social media handle as the price of entry into the country, it's inherently chilling. It's like saying, we're going to be listening to every phone call that you have, and it's just premising the surveillance directly on First Amendment activity at that point, the very core of speaking. And so it's going to have that chilling effect. And that's an argument that we made when the Trump administration sought social media handles during the first time around. We will probably raise that again then in your latest Paperwork Reduction Act request.
We're going to shift into talking about the privacy protection that may or may not exist for social media monitoring at this stage. So we're going to start by talking about the Fourth Amendment and then maybe move into statutory protections or legislative proposals on the front right now. But starting off with the Fourth Amendment. So in your view, how does the Fourth Amendment apply to government surveillance and social media activity, and to, I guess, make that broad question a little bit more specific? Do individuals have a reasonable expectation of privacy here? Is the public nature of social media limit privacy claims in this space?
I think it depends if it's like a normative or descriptive question. Like normative, I think people do expect that what they post on social media is going to be private. And it's funny because even if you have a profile, you're not normally thinking, yeah, I'm putting this out here to be used against me in prosecutions, you know? But especially when people don't have a public profile, you're expecting to have a reasonable expectation of privacy. Do they actually? It depends on the jurisdiction. Some places you do, other places you don't. Some places judges have said, yeah, you have your privacy settings pretty high. You demonstrate a reasonable expectation of privacy, and you know that's reasonable, objectively reasonable. So please need a warrant to see that. Other judges have said no, because anybody of yours who sees that post can just screenshot it and share it around. So you don't have a reasonable. That's not a reasonable expectation. So police can get that. There's really no law against police making fake accounts, even impersonating someone you know, a friend of you, and looking that way. So I think it gets back to this question of like, what is social media data? There are so many streams that they can get at it that you should have a reasonable expectation. They don't. I suspect we're going to talk about Carpenter at some point, which I think would be definitely interesting.
Let's talk about Carpenter.
Yeah, let's do it.
That's my next question. So
Okay,
get right into
beautiful. So, I can't say this is the ACLU's official view, but, if we're thinking descriptively, as Tom sort of framed it, I think that in a lot of ways, and also keeping in mind that there are gradients of privacy and streams in social media. If you think about those public posts, I think that is probably going to be a losing argument in most jurisdictions if you put it out there publicly or a sufficient number of people. That you probably have surrendered that reasonable expectation of privacy. I know you tried to argue quite valiantly in your note using the sort of factors that Carpenter is premised on, that there's perhaps this idea that is such an invasive and comprehensive view of your life that it's going to trigger this First Amendment view, or not First Amendment, Fourth Amendment protection. I think that's probably not going to happen. A number of litigants, including I think the ACLU, have argued about poll cameras, that the law enforcement will climb up a telephone pole when you're out of town, put up a camera to watch when you're coming and going, and then when they bust you for dealing drugs, they introduce it to show, yes, you were coming and going, or people were coming to your place. And people argued under Carpenter, this what got termed the mosaic theory, that it gave such a comprehensive view of your life that it's going to trigger these Fourth Amendment protections. And courts have, unfortunately, I think, pretty much universally panned that particular argument. So when there's that sort of public-facing life that you have, whether it be you out in the streets, or you're coming and going to home, or perhaps even your public posts. Probably not going to trigger the Fourth Amendment. Once you start putting down privacy protections, though, it's rare, all the way to the point where then if you have one-to-one communications, and then that will trigger either the Stored Communications Act, which I'm happy to dig into, or the Fourth Amendment might actually kick in. For a while, people assume that if you send a message, you're entrusting it to a third party, so the third party doctrine is going to leave that vulnerable. That's why we have this law called the Stored Communications Act. But the Sixth Circuit said 15 years ago, nope, there's a reasonable expectation of privacy in your one-to-one messaging. That is going to trigger Fourth Amendment protections. So only the Sixth Circuit so far. I don't know of any circuit split around it, and I know that Google, Facebook, etc., are saying to law enforcement, you're going to have to comply. I don't think there's a circuit split, I think the DOJ is basically seeing the issue at this point. So.
I guess just it's going to be interesting to see how it plays out. I agree. Like ever since Carpenter, people have, and just I think people know Carpenter, but just in case, lots of nods. Should I? Okay. Well, that. Okay. So for a long time, third-party doctrine. If you have even sensitive data, that's like a business record. Start off with data, essentially. The Supreme Court said, "Hey, I know you feel like this is very private information, and we should be able to get it, but you've entrusted it to this third party. They created it about you. Like, you do not have a reasonable expectation of that." This came to a head with cell phones, and in like the 2010s, they issued this case Carpenter, which was like a huge revolution in Fourth Amendment law because it's unquestionably third party information. It is the cell towers that you're flying pings to, which shows your geolocation. And specifically in Carpenter, it's like historical, it's like over a 7-year period. And the court like made this huge leap, and it was actually the last Fourth Amendment case they took up. So it's been like 6 or 7 years now, which is crazy.
That was a 5-4 case.
Yeah, where they said, actually, yeah, that whole reasonable expectation of privacy thing is still good law, but this is so special and we have all these factors for why people actually still do have a reasonable expectation of privacy. Ever since defendants have been trying to use it in different circumstances, and they've actually, I was surprised, I kind of was under the impression, the court basically said, this is just about historical CSLI, but then its reasoning was a lot broader, that's why people were trying. I thought that most of the appellate court cases I saw, they were like, no, that was just about historical CSLI. There's this awesome law review article I just read that analyzed every case in both the public cases as it came out. And it's actually been applied pretty widely. Blood draws, cell phone pings, it's basically just a mess in the lower courts right now. So it's going to be really interesting to see how it plays out. For social media, please.
The only thing I would just quickly add on the 5-4 thing, Justice Ginsburg was in the majority in that ruling. Amy Coney Barrett is now on the court. Justice Ginsburg obviously is on the court.
Yeah. For social media, I think the one factor that's tough is for those cell phone pings, they just happen. You're never saying, oh, let me ping the cell tower. So that's one of the factors that doesn't really match up because if you are putting a post out there, you are kind of taking advantage of that. But I really do think in the current situation, that's why the First Amendment is so important here because what are you doing? You are speaking. So if that's what you're being punished for, we almost don't necessarily need to just work with it. But there are other circumstances in which social media surveillance might not be tied to punishment and speech-based, so it's so important.
Wanda, do you think Carpenter's time is limited, or?
I would have to more closely study the jurisprudence of Amy Coney Barrett. It was interesting that Chief Justice Roberts wrote that opinion and was in the majority. That's a good sign to the extent that he and Justice Barrett have been sort of siding together in the case law. And this whole idea of precedence and preserving that. It's a relatively recent case.
Relatively recent, and this court, when it does overturn precedent and says, stare decisis ad orbit, it seems to be no, but this case at Roe, treated Roe this way, is it was a one-off that broke with precedent. If you read Kennedy's dissent, I'm putting this for note, does such a great job of analyzing it. Kennedy's dissent is basically like, no, this is very clearly third-party doctrine. It should come out the other way. You made up a test, and it's going to be a mess for the next 15 years, which she was right on that point. It's going to have a mess. But so, yeah, that's a great flag. It's like it has some of the hallmarks that this court has used to set things out.
So I want to conclude our call by shifting and talking about policy and reform proposals. So to start, what regulatory or legislative solutions do you think can be implemented to curb excessive social media surveillance? And I recognize that question's broad, and there's a lot of ways you could take that, but.
I have three specific answers, but Monday, do you want to go first?
No, I mean, you seem more excited than I was.
Yeah. three pieces of legislation. One is comprehensive privacy, specifically with the data minimization standard, which got mentioned in one of the panels earlier today. Data minimization being the idea that companies only collect and use the information they need to provide the service requested. So if you download Candy Crush, you get Candy Crush is not secretly uploading your location in the background. That will help with a good part of this, because we're talking about social media, but a lot of the things that law enforcement is accessing are coming from a variety of applications on our phones. The second one, Fourth Amendment is not for sale act, will help a lot. Fourth Amendment for sale is not for sale is this idea that addresses what's called the data broker loophole, meaning a loophole in Fourth Amendment protections where if I want to, for example, know what websites you've been visiting, and my first idea as a law enforcement officer, I'm going to go into your home, get your laptop, and open up Chrome and press Control-H. I'm going to need a warrant for that. However, if I just have some spare bucks in the Doge fund, I can just go and buy it from a data broker instead. Fourth Amendment is not for sale would prohibit that sort of practice. And then, I think that reforms to the Telecommunications Act are essential. I mentioned the Telecommunications Act for a while. It was a law that was passed in '86. That was the idea that was sort of to counterbalance this third-party doctrine regarding our phone calls, early emails, early text messages, because at that time, the consensus was it was a free-for-all for law enforcement. And Congress, in its infinite wisdom, said communications that are sitting on a server less than 180 days, you need a warrant. More than 180 days, a subpoena will work, and sometimes if it's certain subscriber information, they just need a court order that's less than a subpoena. That's not how we think about the world anymore. There's no reason that 6-month cutoff makes sense, especially when we're archiving everything for better or for worse. So those are the three I would put. Comprehensive privacy, which is more of a wish than anything right now. Fourth Amendment is not for sale, which I actually vote behind, and then FCBA reform.
So I'm going to talk to you about facial recognition technology because that's what we focus our report on. AI is broad enough that I'm going to provide that kind of specificity here. And I would also commend to you the approximately 10 pages of findings and recommendations that we published. I'm going to tell you, on a commission that is evenly divided 4-4, it is remarkable that we were able to agree by way of findings and recommendations, because there have been a number of reports, we do about 2 or 3 reports annually in these past few years, where we just could not agree. So we just left out the findings and recommendations portion altogether. And so we're really proud that we were able to get to yes on that, and I think it speaks to the bipartisan interest in this issue. There is no federal statute that explicitly regulates the use of facial recognition technology by the federal government. That's a problem. And so Congress should do something about that. A lot of this stuff can also be done by executive order, but not all of it, and in many instances not the most important stuff. There needs to be some provision for legal redress when constitutional and statutory rights are violated, so as to make people whole again, and so as also to disincentivize bad behavior. I mentioned earlier that these departments and agencies that are using facial recognition technology should publish their use policies on their web pages and otherwise to the public, so that we can independently come to our own assessments. To the extent that the federal government is giving dollars to local law enforcement agencies and to housing authorities, which also use facial recognition technology, again, to devastating consequences in many instances. Imagine people not gaining access to their apartments because of flaws in the facial recognition technology that's being used to gain them access or to deny them entry. when defendants are being charged with a crime and facial recognition technology is one or more of the bases used to get to that point, that should be disclosed to defense counsel so that can be challenged if necessary in court. Yeah, I'll stop there.
I'll co-sign everything both of on there said, and I'll just add one other thing, which was, we saw the city of Oakland institute a surveillance oversight board, which was very cool, mostly focused on facial recognition. I know that, I think there have been some, I know not everything's gone perfectly, but you know, there's a lot of collaboration through these things, public fusion centers with local, state, police, and federal agencies. And I think one way to give people more control over social media surveillance being done with them would be to spread these community-based surveillance oversight boards more broadly, and to have them not only okay face recognition, which is obviously incredibly important, but also social media surveillance. So it's not something that police departments are just doing willy-nilly as they are now. I don't think many communities, if you ask them, would be okay with officers impersonating people they know with fake accounts and look at their profiles, and I think that would be something that would be properly overseen. So.
Thank you. I think we will open up for some audience.
Yeah, thank you all again for being here today. I had a couple questions specifically for Commissioner Jones because I found your report incredibly fascinating. And I know a lot of the conversation is centered around social media surveillance, but facial recognition surveillance is increasingly prevalent and also a major issue. So I know you mentioned that there's no federal legal framework right now for litigating these cases. What older frameworks have been applied for these cases at this point?
So it's a great question. You know, we've seen such technological advancement just in recent years that I think lawyers are struggling to catch up. You know, you could make claims under the Fourth Amendment of the Constitution. You could make claims under the Fifth Amendment of the Constitution. But, you know, now I'll certainly defer to the lawyers who are practicing in this constitutional space, who are sitting to my left and to my right. I think there's been very limited success when it comes to that. And candidly, a lot of people just don't know that facial recognition technology is being used against them because that information just never disclosed or rarely disclosed compared to the billions of searches that are done every single year, including by the federal government, which does an absolutely horrible. In fact, the federal government does not make an effort to keep track of its use of facial recognition technology, with some exceptions. The Department of Homeland Security, ironically, does a better job of at least trying to standardize its use of facial recognition technology than the Department of Housing and Urban Development, which is just like making a whole bunch of grants to housing authorities and then not tracking like whether that's used for, you know, whether facial recognition technology is used and how. The reliance on Clearview AI, which again, not to pick on Clearview as a company, because you know none of these companies are perfect. The pervasive reliance on it is, I think, a real challenge when you don't have a so-called human in the loop. I mean, there was testimony given by the CEO. I was able to get him on the record saying that prior to human intervention, there's a very high rate of error.
A quick follow-up question I also wanted to ask is, I know that you mentioned when you were speaking earlier that there wasn't always agreement between the commission and past reports as to how to proceed. What were those disagreements and how is that different now in the report that you want?
So I've been on the commission. I'm the one who led the report here. so I make sure we had a robust work product. Honestly, yeah. But also, you know, I was not on the commission prior to January of 2023, and so I can't speak to disagreements in the past. But there have been some even since I was appointed, and you know, some topics are just more controversial than others. When you're doing a report on anything involving crime or more traditional civil rights, shall we say, what you observe in our national politics, the polarization, is, it starts to manifest itself. But I know from my time serving on the House Judiciary Committee, where I was sometimes surprised to see unusual alliances when it came to the skepticism towards some of the practices of the largest technology companies in our society, particularly in the antitrust space, where I found myself, and we come to this from different perspectives, to be sure. Conservatives oftentimes think that these companies are suppressing their speech. I have more traditional antitrust concerns, but if we end up in the same place, great. And so I knew from that experience that there would be an opportunity to reach some kind of bipartisan agreement. And I also come to this without really preconceived notions. I mean, I don't think that we should do away with racial equity. I think there are a number of, as I mentioned earlier, compelling use cases. But it does need to be regulated much more than what it currently is. Which is to say there's precious little regulation at all, to say nothing of the utter lack of interest until recent years. And I do think that our report is in the process of inviting people to testify has spurred some of these agencies and departments to action. But there's just, the record keeping has been abysmal when it comes to this.
Thank you, Vaishali. Gentlemen, thank you for your remarks. At the end, you talked about legislative steps to address some of these issues, but none of these legislative or policy changes are going to come anytime soon, whereas the people who are affected by this, those who are protesting and others, are facing the consequences in real time. So with your expertise, what are some best practices that you could recommend to ordinary people affected right now as to how to avoid some of these problems? Is it just deleting their accounts, or making their accounts private, or wearing a mask in public? What would you suggest to people in this situation?
So it depends on your risk tolerance as an individual, and this is getting toward like surveillance self-defense. And EFF has great resources, Electronic Frontier Foundation. They're a little dated now, but they're still pretty good. And some of the things that you just listed are options on the table, but it's not always realistic to ask everyone to delete their social media account that they have, to sit down and go through the apps on your phone one by one to figure out which one are reporting your data back. Because again, social media is the focus here, but it's not the only source for a lot of this information, including many of the companies that we've been talking about. They pull from all sorts of other sources, including data brokers. So some things that are potential, masks are an option to help defeat facial recognition technology, knowing to disable phone or use a dumb phone if you're going to a protest and things like that, using encrypted technology, signals better than news, here's your signal, not good for classified information, good for a lot of other things. And so it depends on your particular risk tolerance. And you can go so far as to adding certain extensions to browsers, or actually now with most modern browsers, it just depends on the settings that you toggle, so it's not reporting back your web activity. And then in addition to that, you could really go extreme and use Linux and use a stripped down system. The smartest tech guy I know at the ACLU, he has a dumb phone, he does all his note taking on pen and paper, and he is untraceable. So up to you if you want to go that far. If you're interested in that lifestyle, let me know. So,
thank you all for being here today. Considering remedies, specifically in the context of AI and facial recognition, I'm curious to hear your thoughts about the provision in the Clearview AI settlement that was approved last week about the provision of equity stake for members of that class, and just like, what do you think about that as a remedy, particularly when you start to consider, does it mismatch incentives?
That's a great question. I will confess that I was not familiar with the settlement last week. It was pretty new.
Personally, I think it's really perverse to tie the interest of people whose privacy was invaded or harmed by Clearview AI, to tie their being made whole to the success of the company. It's just, I think it's.
Oh, the equity stake was in the company?
Yes.
Yeah.
Yeah, the class. Yeah. I don't know if I have much more to say.
I thought you meant equity like fairness. Yeah, there needs to be a robust statutory framework to compensate people when their rights are violated. We see this in so many other important contexts. I think it's call it a personnel failure when it comes to the people who are in Congress that they've not focused so much attention on technology. So hopefully we'll get some younger members and some people who are otherwise just thinking about these issues.
Yeah, it's kind of fascinating that so much ink and committee time has been spilled on children's privacy or children's safety / children's content online, which we got another debate about that earlier sort of tiptoed around. But almost none on facial recognition technology whatsoever. So it's, wild if that's the case.
And there have been some leaders on this. I'm just shouting out, Ted Lieu in California, Vivek Clark, who serves on the Energy and Commerce Committee, has some legislation. So there's stuff out there. I'll confess, it wasn't sort of top of mind for me when I was serving either, but it's only becoming more important.
Senator Berkeley from Oregon he got stopped by TSA facial recognition technology. His jam since then, and it's amazing. Many of his bills are largely about either let's freeze the technology until we have a report about privacy invasion, whether it makes lines safer, whether it makes lines faster or airports safer. He just wants information, and it just cannot get traction. It's even bipartisan. So
you just brought to mind another recommendation. For non-enforcement purposes, you can opt out of a lot of this stuff in the airport, but you would never know it because your ability to opt out is not effectively communicated to you. It's effectively hidden from view, even though they say, they make that option available to you. And so one of our recommendations is to more prominently display people's rights to opt out.
I'm just curious, do any of you opt out of the airport?
every time.
Oh, really? I thought I was
I've
just
got
like a
nothing
thing.
My stuff is all out there.
I do appreciate that. We were running a bill in New Mexico, a privacy bill, and someone had the other one. Let's go buy the legislators' profiles off data brokers and show them this is all the information on them. I said, well, there's some ethical issues there. Let's not do that. They're like, well, what if we buy it out ourselves? I'm like, okay, that's consent, willing participants. So I was the one tasked with going to their brokers and buying the stuff. My file is the biggest by a long margin. And partially just because I live a very public lifestyle. I write a lot, trying to influence policy. So you Google my name, I go on for pages. It helps I have a pretty unique name. So versus Thomas McBride, you might hide behind lots of people. I don't know. Weirdly,
I'm one of the only beats.
it's that
It was an Ellis Island mistake, but
yeah.